Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources.
Today we're going to be talking about the importance of of crisis planning. And for an elder law point of view, we look at crisis planning on providing immediate legal solutions when an elderly client, usually, it could be someone who's not elderly, but it's usually an elderly client, where they are suddenly facing a health crisis or the need for long-term care, which is a very nice way of saying probably nursing home care. Okay, which, as we know, if you have know anyone that's ever been in a nursing home, it's very expensive. Nursing home care in Brevard County is going to cost about $12,000 to $14,000 a month. It's very pricey. So that will very quickly use up most people's nest eggs. And also there's people who are concerned about, I don't want all of my assets to be used up if I have to go into a nursing home. So those are a couple of things I'm going to talk about because that can be avoided if you get the right help. So a elder law attorney's primary objectives in crisis planning are going to be to preserve the client's assets and to make sure they're receiving their necessary health care. We don't provide health care, but we want to make sure you have someone who has the legal authority to help you with that. And we also want to make sure that you have someone who has the legal authority to help make legal decisions for you. Pay your bills, go to the bank, make other types of decisions, talk to the Social Security office, talk to the insurance company, talk to Medicare. You will need to have someone who has the legal ability. And just because you're married doesn't mean anything. You may not be able to make legal decisions and likely won't be able to make legal decisions for your spouse, even if you're married. There are some exceptions for healthcare. You may be able to be declared a proxy, a healthcare proxy, but that's facility by facility. That's not just across the board. So we want to make sure you have the paperwork in place that no matter what doctor you call, hospital you go to, or other type of medical provider, that you can have access to records, information, talk to people, have that HIPAA release. Also, when it comes time to making legal decisions or financial decisions or decisions about assets, want to sell the house, want to help with the banking, that's maybe a bank account that's only in your spouse's name, you need to have a durable power of attorney. You have to, or you're not going to be able to help them. All right, so when I do crisis planning, I take a couple of approaches. I'm going to want to try, if I can, to do some asset protection in the event that they have to go into a nursing home. So I'll do some Medicaid planning, maybe help with some Medicaid planning strategies, and be strategic with planning to meet strict asset and income limits that are under Medicaid. So in order to qualify for Medicaid, you have to have income, and I don't have my chart in front of me, and that should have been a handout here today. Word to the wise, Winter, my assistant back there. I'm going to give you round figures. So the income changes every year. So currently it's around $2,849 a month, I believe, is what the income limit is. That's really low. Some of us, just with Social Security, maybe a small pension or your IRA RMD or your 401k RMD, or maybe you have VA pension money coming in, that can easily pop you over that amount. And if you are one penny over that amount, you will not qualify for Medicaid. And you will need to have what's called a qualified income trust done. And that's a special kind of trust that allows someone who's over income to qualify for Medicaid nonetheless. Here's where we have the problem. Typically, when someone comes to me and says, I need to help my husband, my wife, my mother, my father, my sister, my brother get into nursing home, and we have just found out from the business office at the nursing home that they are running out of Medicare days. So I don't know if you know this or not, but Medicare does not pay for long-term care. Medicare will pay some time for rehab. If you had to go into the hospital and then go to a rehab center, Medicare will pay for a certain amount of days, but Medicare is not going to pay for long-term care. And long-term care is nursing home care usually. That's when they usually call us because they've been handed a bill for next month. And the bill is going to be $10, $12, $14, $17,000, depending on the facility you go to. There's some are less expensive than others. And that is a shock to the system when you get that bill. And usually when we get called, we are dealing with a crisis. We need to get Medicaid approved right away because they can't afford to pay the bill. So we scramble, a lot of scrambling. The first thing I will ask is, does your husband, spouse, or whoever it is that's going into the nursing home, do they have a durable power of attorney? I need to know if you, the person in front of me, has the legal ability to do this for them. Number one, do you have the authority to help your mom, your dad, your sister, your brother, your spouse even? And if the answer to that question is no, my next question is going to be, do they still have the mental capacity to sign legal documents? If the answer is yes, then we will do whatever we need to do to help you with getting documents set up, even if that means us driving to the nursing home, to the hospital, to wherever the person at, as long as they're in Brevard County, to help that with signing and getting legal documents updated. If they say no, they don't have capacity, and I find out that there's certain techniques I'm going to have to do to get them qualified for Medicaid that will require a durable power of attorney or other type of authority to do, then the next step will be, well, since they don't have capacity, since there's certain work that needs to be done that will require you to have the authority to do the work for them, and they don't have a durable power of attorney that allows you to do that, then I am going to have to file for guardianship for you, for your loved one. And we will have to, once the guardianship is established, ask the court for permission to do the Medicaid planning for you that you need so desperately. The problem with that is it's time consuming, number one, because you're dealing with the courts, and anytime you deal with the courts, time slows down, okay? So we want to try to avoid the courts, and I could just simply avoid it just if I had that durable power of attorney. The other reason why you don't want to go through guardianship is because it's very pricey. It's very expensive. A typical guardianship will probably cost you about $7,500 to $10,000 just to establish. And then guardianships last usually for the lifetime of that person. And there are requirements that you have to do every year, and you have to have an attorney. It's required. So the cost of the guardianship doesn't go away until the person dies. Okay, so we want to avoid guardianship, and we avoid guardianship by making sure we have proper legal documents in place that will allow someone to be able to help make healthcare decisions for you and legal decisions for you. One of the things to do to avoid a crisis, or to plan for a possible crisis when it comes to elder law, right? There's all kinds of crises to plan for, hurricanes, all sorts of things. That's why we buy insurance. That's part of crisis planning. But for me, in elder law, crisis planning means let's make sure you have the legal documents you need. So I look at estate planning for that. And when a client comes to me for just a regular estate planning consultation, not even a crisis going on, not even a hint of crisis going on, just a regular estate planning consultation, I want to know two things. Who is going to take care of my client if they lose capacity and cannot take care of themselves? Number one. And then number two, how are we going to carry out my client's wishes when it comes to their things after they pass, like taking care of their family? Maybe they have a disabled child I need to think about. Maybe they have a disabled spouse that I need to think about. And also part of that, the part B part about what do we do with your things and how do we treat your things and make sure your wishes are carried out. I also want to avoid probate for you if possible. Okay, so probate is another court procedure, also pricey, also time consuming, and is completely avoidable most of the time if you plan for it. So to avoid guardianship, we're going to plan for it by making sure you have certain documents in place. To avoid probate, same thing. We just make sure that you have certain documents in place. And part B to that is making sure that your assets are either structured in a way to avoid probate or they're held in a certain manner to avoid probate. So what I mean by that is maybe bank accounts. If you have a very simple plan, nothing crazy going on, and you just have like one kid or two kids or a spouse, you can just name them as a beneficiary in your bank accounts. You can just name them as a beneficiary on your life insurance or on your 401k or other types of accounts. And that will avoid probate. So one of the tools that we'll use in our toolbox when we do estate planning is a revocable trust. We'll use a revocable trust to hold assets in. You don't have to be rich. People think, oh, a trust, that's only for rich people. No, that's for people who want to avoid probate. It's also used to help avoid guardianship because whatever assets the trust owns right now, if you lose capacity and can no longer be the trustee of your own trust, well, that's okay because you have probably named somebody to take over, step into your shoes as your successor trustee. That helps avoid guardianship while you're alive if you lose capacity. And then after you pass, whatever the trust owns can be distributed in the manner you want without having to go through probate. So it's a win-win. Revocable trusts are very helpful. If people have certain assets that I know are going to require some special planning to avoid probate, I'll often talk to them about a revocable trust. If you're going to leave assets to a child under the age of 18, I'll talk to them about a trust. These are ways to avoid guardianships and probates. So typically, if you own a home, a trust is maybe a good idea, maybe. It's case by case. I'm not going to say blanket everyone that owns a home needs a trust because that's not accurate. Okay. So the next document, very common and most common document in estate planning is the last will and testament. Everybody's familiar with that. We use that document to say, do I want to be cremated? Do I want to be buried? Who's going to be in charge of my estate? This is how I want my stuff divided up. But please understand, wills do not avoid probate. If you have a will, your assets will be distributed the way you set it up in your will, but it will likely, depending on the asset, but likely will need to go through probate. And if you can avoid probate, you should. Now, if you get a trust, you will still get a will, but it's a special kind of will. It's called a pour-over will, and it's designed to work with your trust. And what I mean by pour-over is just what it sounds like. It pours over into your trust. And then the trust does all the heavy lifting, and that could be a way also to avoid probate when you have a trust and they work together. The next document, and I've already mentioned this probably a half dozen times, is the durable power of attorney. To me, that is the number one most important document a person over the age of 18 can have to avoid guardianship. I take care of guardianships for children who have been abandoned or orphaned. So I have guardianship clients from infants all the way up to 100 years old and every age in between. But this particular type of guardianship that I'm talking about is the kind of guardianship that happens to someone who's over the age of 18 and they lose mental capacity for some reason. Usually, if it's a younger person, it's because of an accident. I've had very young people that I've had to do guardianships for, 17, 18 years old, because of accidents. And it's very sad. But when you have young children and they're turning 18, I always talk to parents of young adults and say, hey, I'm not thinking that your 18-year-old needs to have a will and a trust and a blah, blah, blah. They don't need anything like that. But I would recommend that anyone over the age of 18 should have a durable power of attorney and a healthcare surrogate, because you do not know what the future could hold. Accidents happen to everybody. But this document is the number one document to keep you out of guardianship if you were to lose capacity due to a health incident, due to an accident, due to just about anything that would affect your capacity. And they're relatively inexpensive when compared to the cost of a guardianship. And it also protects your privacy, because I didn't mention this, but guardianship means the government is in your business intimately. And who wants that? I don't. All right, so the next document is the designation of healthcare surrogate. That is the number 2 most important document to keep you out of guardianship. This is just what it sounds like. You are designating someone to make healthcare decisions for you. A well-written designation is also going to include HIPAA release information. The next document is a living will, and this can sometimes be misconstrued and misunderstood and confused with a last will and testament. This document is not the same thing as a last will and testament. This document is about end-of-life care, and it really speaks for you in the event that you cannot speak for yourself, you're unable to communicate, and you're in the active dying process, and 2 doctors have determined you to be in the active dying process. This document speaks for you. It can be edited any way you want it to be edited. It can be edited to fit your religious beliefs. But in a nutshell, typically it's going to say, keep me comfortable, give me pain medication, but don't plug me into machinery and don't keep me alive artificially. That's a typical living will. The next document is what I call the Plan B. We do not want you in a guardianship. We are going to do everything we can to keep you out of guardianship, but in the event that you need one anyway, this is a declaration naming pre-need guardian, and what it does 2 things. You can use it to state who you would want if you had to have a guardian, and sometimes more importantly, you can use it to say who you do not want as your guardian, because almost every family has somebody in the family that you love them dearly, but you do not want them making decisions for you. So you can name them as someone that's disqualified. So planning pitfalls, Kerry touched on that a little bit. Yes, I have reviewed documents that were drafted by a criminal law attorney, and they were atrocious. And they were done by a criminal law attorney that practices law less than a mile from my office. I know him very well. And I told him, this was terrible. You're lucky that I got involved, because I'm going to fix this problem, but you pretty much committed legal malpractice here. Don't do this anymore. Stick to criminal law. He thanked me for that, but anyway. If you have your documents drafted by someone other than someone an attorney who practices regularly in estate planning, you may want to have your documents looked at. If you have documents that are over 3 to 5 years old, you should have them looked at periodically. It's recommended every 3 to 5 years. Occasionally, the law changes, and it could affect the way your documents are able to be used. That's the reason for that 3 to 5 year review. But if you have out-of-state documents, you moved in from out of state, you brought in your old documents, definitely get them up to date with Florida-specific documents so that you have what you need when the time comes. If you did it yourself, you downloaded your documents from the internet, you need to have your documents probably redone. If you went to a paralegal service, a place that is independent from an attorney, you probably need to get your documents redone as well. I've seen documents drafted by all these types of people, all these types of entities that are problematic, especially when it comes to Medicaid planning, because like I said, I'm looking for certain authority to be able to do Medicaid planning. And I'm going to tell you right now, if you had a power of attorney drafted by Patrick Air Force Base, and you need a qualified income trust when it comes time to do your Medicaid planning because you're over income, you're going to have a real problem with that power of attorney because it does not give Medicaid powers. In Florida in 2011, certain powers became what's known as superpowers. And these superpowers have to be initialed, and they have to be initialed next to the superpower. So sometimes you'll get these out-of-state powers of attorney where it'll say power A, B, C, D, E, F, G, and then down at the bottom it says, I grant all those powers, all of the above. Well, Florida says, you cannot do the all of the above option. Florida is specific and says you must initial next to each power. So that logistically becomes a problematic document when it comes time to use it in Florida. So these are all pitfalls to watch out for. And if you feel like you have any nervous belly going on over any of these, just have your documents looked at. Okay. What happens if you don't? What could happen if I don't have a crisis plan? Well, you could end up in a guardianship. It could delay the whole process, especially if you're going into a nursing home and you're getting that big bill. It could end up costing more because you might have to privately pay that bill while we try to get you ready for Medicaid because of the delay. Also, if you don't have documents in place, not only could it be a problem with guardianship, if you pass away and you don't have documents in place, then the state of Florida has a plan for your estate, and it may not be the plan that you would have chosen for yourself. So it's better to have your own plan, put it in writing. Okay, and what if you already have estate planning documents? So I kind of already touched on that. You should have them looked at, especially if they're out of state, if they're old. If anyone that you named in your documents to be in charge of anything has lost capacity, has died, or you simply just don't like them anymore, get your documents updated. And how not to go broke when faced with the crisis of nursing home care. That's a big one. And that's where Medicaid planning comes in. Because nursing home care is expensive. So we do Medicaid planning to get people on Medicaid. Medicaid will pay for nursing home care. Medicaid will pay for your time in the nursing home, the care that you need, and your room and board if you have to go in the nursing home. So what this tells you is the cost of care, home care services, $4,500 a month, and maybe more than that. That might be it depends on how much services you need, frankly. But that's usually someone that's going to come in, help with some housekeeping, maybe do some laundry, cooking, light things, not nursing, not hands-on nursing. They might help you take a shower, things like that. Assisted living care, this one says $5,200. I'm going to tell you, you may be able to find some assisted livings for that price, but the real nice, fancy ones, the ones that we see, and they're like, wow, like Zon, great place, but it's not going to cost you $5,200 there. It's going to cost you significantly more. And also, it depends on how much care you need, how much assistance you need as to how much they're going to charge you. And then nursing home, semi-private. Semi-private is just a nice way of saying you're going to have a roommate. This price is from 2021. It says $7,900 a month, and I think that's low even for 2021. And you're not going to find that in Brevard County. That no way. It's going to be $12,000 or more a month for a semi-private room. If you want a private room, it's probably going to be $15,000, right? Yeah, about $15,000 or so a month. It gets quite pricey. So how do we pay for this? Well, there's 3 ways to pay for care. You either are going to purchase long-term care insurance, which I don't sell, but you can purchase from most places that sell life insurance and that type of insurance. But long-term care insurance can help keep you at home longer, help pay for care to keep you at home longer, or if you end up going into a facility, it could help offset the cost of care there as well. So it can be helpful. Self-pay, that's great if you got enough money to self-pay. But the majority of people in nursing homes, 50% or more, are going to be getting paid for their care through Medicaid. Medicaid has a means test, which means that we will be, as part of the application process, I do applications. I help people apply for Medicaid. I help them prepare ahead of time to make sure when we do the application that you get approved. And so we will be looking at your income, and we will be looking at your assets. So how can an elder law attorney help? Well, elder law attorneys such as myself, we are very well versed in the Medicaid rules. Not every attorney understands Medicaid rules. In fact, I'm going to tell you that only elder law attorneys understand Medicaid rules because nobody else deals with them. Nobody else deals with them except us. So it's not something that your family law attorney can help you with, or God forbid, your criminal law attorney. It really is a specialty, and you should talk to an elder law attorney if you are thinking that you may one day need to get long-term care and you don't want to go broke doing it.
I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses, and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.